Good morning, everybody. I just want to tell you right now, it is not a good idea to give me more time. So with that said, though, we're going to start this off. What I want to do is really talk to you about how the court systems look when a breach occurs. When I don't get the phone call that sounds like this. Hey, Doug, how are you doing? Oh, I'm doing fine. What can I do for you? Oh, nothing. I wanted to call and say hello. No, I don't get that phone call. I get the phone call where something has not gone well, and then we have to sort of deal with it. I saw an increase in 2020, a slight decrease in 2021, because I think people started paying attention to that. By way of background, I think it's important to know who your speaker is. I was a physics major undergraduate, a computer programmer right out of college, went to business school, went to law school, discovered this thing called intellectual property, 25 years ago, and then ended up doing a lot of techie stuff in the legal industry just because of my background. And what I want to be able to do is not so much talk to you as the law, but how the law applies to what we're really doing. So we'll start off with this. One of the things I don't like about having this subject matter at all is that you've got the consumer, the vendor, and the company, and when there's a breach that occurs, the issues are between the two people who didn't do the hack. The bad guy, the hacker, the breacher, they're not involved. So you're now dealing with two people like this. The customers for Target sued Target. The hacker was gone. And we see this a lot. So we're having to deal with a problem not of that making. Disappointing, but that's just what we're having to deal with all the time. The nice part about that is that since it's really difficult to point to one of the people in a dispute and to be able to say, hey, that's the bad guy, we sort of have to look at what the behavior was before the breach, and that's what I want to talk to you about today. Security, what we can learn from litigation theories, contractual provisions that we're trying to do to mitigate the risk, and then software development, this open source, agile, waterfall, security that goes into software. Don't answer this question right now, and I don't want to pose this to any of the software vendors, but whenever you get software developed, we are not seeing the software vendors themselves getting into the security that needs to go during the development process. That has become magnified with agile, which I get a kick out of because I'll talk about agile in just a minute. Anyway, the point of that is that when you're having software developed and when you're looking at the contracts that you're writing to get software developed, we're not dealing with the security aspects that well at all. I mean, not at all. And I'll give you, a little later, I'll give you a couple of examples of how the contracts and the process are not going together at all. But anyway, let's talk about litigation theories. What a litigation theory is nothing more than what some attorney says, hey, here's the legal theory in which I'm going to sue you over. So here we have to figure out who we are first. Who are the ones that we're dealing with? South Carolina Upstate Alliance says that there's 2,080 engineers in the manufacturing companies in 2022. That's just in the upstate, by the way. Okay? So we've got a lot of manufacturers. Number of the defense contractors in South Carolina, over 4,000. I apologize for this next number. There's over 10,000 lawyers in the state. Sorry. However, South Carolina does have one of the lowest per capita attorneys in the nation, right? So we're not one of those people that's flooded. And then we have, over 2 million civilian workforce. So that's what we're dealing with. And every one of these people potentially could be subject to some type of security issue or should be dealing with it, every single one of them. We are seeing a lot of the law firms get hit more with hacks, breaches, mostly ransomware, and phishing scams and wiring money to places they shouldn't. That's what we've seen the most over the past 3 or 4 years for the law firms. One of the big areas that we're doing right now in South Carolina is we're taking and we're automating the manufacturing floor. We are not handling the security at all on the manufacturing floor. I'm telling you that right now. This is, I love the word IoT. I have friends of mine who are in the techie space that will not use Google Home or Alexa because they don't want their dishwasher to be talking to their Wi-Fi network. Okay, a little extreme, I get that, but I understand the concept of it. The point of that is this is who we are. If anybody is out there dealing in the industries, and the industries are anything like the manufacturing space, this is absolutely a topic you should be talking about because the stuff that's being wired inside a manufacturing plant right now is crazy. I mean, it's doing all kinds of things. Well, I can't share that story. My daughter worked for a major manufacturer in the summer as an internship, and I got an opportunity to sort of see how are we dealing with the security at the IoT level, and let's just say there's a lot of improvement that could be made. Primary legal theories, and I did a poll, and the poll that was done on the app for this thing, it was close. Negligence is the #1 legal theory that's being used. Breach of contracts and regulatory are 2 and 3. For the most part, the audience who responded to the poll underestimated negligence, overestimated breach of contract. Okay, but nevertheless, this was pretty close. And the negligence, what I like about the negligence cause of action is there's things that we know how to do and we have a lot of control with it. The contractual cause of action is actually hard. And the reason it's hard is, and which we'll talk about later, is if you look at the way most people write software development contracts, with all due respect to our legal profession, most of them have never written code, they've never run a software project. So the software contract development, the vendor agreement, and the actual work don't really fit that well. So when we get into the fight about the contract, it starts falling apart a little bit. So anyway, first we'll just talk about negligence. South Carolina, this is all stuff all the lawyers know. Here it is, it's breach of duty, that kind of stuff. It's this first one that I really like because we have to define the duty. This can make or break a case. What is your duty? What was your duty owed? I remember a zillion years ago, my torts professor told me one thing. He said, just because there's an injury does not mean there's liability, right? And that really stuck with me because unfortunately, if you think about the way the media and the world and society has gone, we kind of say, oh, I got hurt, someone should write me a check. I mean, that's a general philosophy we've kind of put out there, but that's really not the case. So defining this duty is actually a very, very big deal. So the question now becomes, what is your duty? It's not written anywhere, it's industry standards, it's not industry standards, it's what an expert says, it's what your IT department says, it's all over the place. But the nice part about the duty is we can actually handle that now. We can create things and get people to agree to things and kind of deal with that so we know what we're doing. There's a lot of other legal theories, but again, just to sort of accent the point, the legal theories that started negligence is by far the first one by a lot. So when we're talking about a duty, what do we really want to do? What is it that you should have done or shouldn't have done? One of the best ways to do that is to either use an existing standard, and the South Carolina Department of Archives has a pretty good destruction policy, so when we talk about that, I can use that. The NIST, ISO have good standards. Those are challenging, and the reason they're challenging, they were designed for large companies and large industries, and they're expensive. To get through that type of certification is challenging. I apologize for that, but I have to do it, but take pieces of it. Security policies is probably one of the ones on a checklist that I think everyone should have. What are your policies? How do you deal with it? The reason I want to emphasize the checklist greatly is because when we're in front of a jury or we're in front of a judge or we're trying to deal with a breach and everything's gone awry and we've got the customer and the company and there's a dispute and they're suing each other, we want to use a checklist the best we can because we want to be able to say, hey, did you do this? Yes. Did you do that? Yes. If I am defending a company that has had a breach, I want a long checklist and a lot of checkboxes. If I am on the other side suing a company because there is a breach, I want you to have a short list and not a lot of checks. Now, as an attorney, we get to argue both sides. We're taught that. And I actually think that's a little weird sometimes. I have a personal opinion about this that I will share later, but let's get through what I think a duty, the ability to show the duty really means. If you have security policies, you have to follow them. So I'm going to start asking questions like this. Do you guys have a cybersecurity checklist? Most people are going to say no, because it's not going to be this. I will say, do you have security policies? 50%-ish, maybe more, will say yes. Then I'm going to say, do you follow them? And they're going to say yes almost 100% of the time. Then I'm going to say, all right, give me the list, let's start going through it. And that's where it starts breaking down a little bit. So if you're going to create a checklist and security policies, make it things that you're going to follow. Because remember, I didn't say they had to, I want a long list and I want a lot of checkboxes, right? And you can control that. Let's look at the security policies, look at the training. This is a big deal, right? I mean, don't answer the question, but I can tell you right now, if I'm an attorney and I'm walking in, I'm going to say, hey, when's the last time you did cybersecurity training? Is it weekly, monthly, quarterly, yearly? Who attended? Did you allow anybody to be absent? Or are they not? Is it required? How can you prove they attended? How many people were doing the security policies and they weren't, and they were on their phones? Without sharing too much, I had the situation to where we had people who were taking remote security classes. The company implemented online security. The one thing about a computer is it does what? It logs keystrokes, it knows what other apps are open. There was not a single person who was focused on the security training. You could tell that from the information, that the emails they were sending, the Word documents they were editing while they were looking at the videos. You could pick all that up. And a good attorney is going to go after that. and this case is going to be over pretty quickly because the company doesn't want that one to go forward. Response plan, yes, you should have a response plan. In my opinion, the response plan, don't overkill it. The response plan should be something like this. We periodically test. If we find a problem, we call our vendor, our insurance carrier, and our attorney. You don't have to build a response team internally unless you feel like it, but you don't have to. Matter of fact, I am of the opinion the response team should involve internal people as little as you can. This really ought to be the external people who are coming in objectively and to do that. Okay? I mean, I think that's kind of a big deal. A breach communications plan, I'm not seeing a lot of people do this. If there is a breach, or even an anticipated breach, how are you planning on telling people about this? Not the reporting requirement. You know, everybody should know by now, South Carolina says if it's encrypted at rest, you don't have to report. If it's not encrypted, you do. Everybody should know that by now. That's not what we're talking about. How are you planning on talking to your customers? How are you planning on talking to the rest of the workforce? Not with security breach, but having a communication response plan is a big deal. I had the opportunity to work with one client who was a public entity, had nothing to do with security, and the floor was slick, and some poor person slipped, and their head hit the floor, and it was marble, and it echoed throughout the lobby. Okay? This is a slip and fall case, which I don't do. The next thing I saw, how I got involved with something else, start seeing text message and emails. Oh, that hurt. Wow, I hope she's not going to be hurt. Is anybody calling 911? She's going to sue us. Well, here's what I would sue us for. This was the internal communications that were occurring during that event, which should never have happened. So this communication plan, I think, is a very, very big deal. Many, many more. These things should be tailored. For example, my law firm is all cloud-based. I don't have a server. For about a year or two, I kept getting phone calls about people wanting to sell me a firewall. My security plan is not going to say, is my firewall up to date? I don't have one, right? So the point is, it's tailored for whatever you're doing. Contracts. So what we're going to talk about briefly with contracts is that we have really, really gotten away from contracts that match the real world. I'm incredibly used to the technology and the subject matter outpacing the law. I'm used to that. That is just how I've lived for 2 decades, and that's going to continue. One of my favorite judges in the state is a judge named Margaret Seymour. She's a federal district court. She's a marathon runner, so when she's coming at you, you can't really run away from her. You know, she's going to catch you, so you got to talk to her. So anyway, I was in front of her one time, and she says, well, Mr. Kim, do you have any authority for that? I was like, no, but this is the best I can do because this is the subject matter we're dealing with. I've become very used to that because that's okay. When we're talking about contracts, the gap's really large right now, and I would really like to see it close. Gap number 1, how many people here have been, well, you don't have to answer the question. A lot of us are dealing with software licenses, right? Software license agreements, everybody's dealing with that. We are moving toward a cloud-based SaaS model, which is a subscription agreement. The license and the subscription agreement are very different. When we get into discovery, we want to be able to see the multiple versions of the software that you have. Well, if it's an agile SaaS model, we may or may not have version control. We may have commits, but we may not have version control. So we're separating that now. The contract provisions are really trying to balance the risk of a problem between the customer and the vendor, the software developer. So one of the things that we're trying to also say is when we're talking about the customer, what does the customer want the software vendor to do? Do some type of software project, but who's handling the security of that? Literally yesterday, I got an email that says, hey, so-and-so has put some, I love this term, some illegal code into our program. I haven't figured out what illegal code yet is, but here's what they meant. We have found out that there is a pixel in there, and that pixel has opened the door to potentially malicious code coming in from a third person. It created a backdoor. Okay? I don't think that's true, but that's what we're talking about. Is it the customer or the vendor who should be responsible for that type of issue? The contracts, what are contracts designed to do? Explain and keep us out of court. The contract should say, all right, here's what's going to happen in that case. We're not handling that well at all. The vendor, on the other hand, has to limit liability because there's a business model here. There cannot be unlimited liability on a vendor. It is unrealistic. And some of the customers are trying to say things like this. You'll indemnify us for anything we have to spend on a security breach that has to do with your code. That's not realistic. You know, we do need to have some types of things that we put in there that make that happen, but that is not realistic. There's got to be some type of balance or some type of plan. And here's sort of the thing to keep remembering is we're trying to manage risk against a person that's not invited, that's not at the party. Two people are trying to manage risk for somebody who's behaving poorly that's not at the party. So that's what we're trying to do. We are all trying to take care of a problem created by somebody else. You know, we do the best we can. I mean, the house that I live in has a deadbolt by the door, right beside a glass pane. Okay? If someone wants in, they're coming in. How are we going to handle that, right? As a small side, and I will not get into this, my wife is a firearms instructor, so our solution might be a little bit different than some other people's. But your situation is going to be different based on what your type of incident is, and you have to negotiate with your vendors and the customers, have to negotiate and figure out what the best solution is. Oh, we're doing good. This is sort of somewhat of the extremes. I just wanted to point out I don't like slides with words. What's the top one? Vendors shall comply with the customer's third-party management standards related to cybersecurity, which will be provided upon request. I love this clause because the vendor now has to comply with standards that they may or may not have. Okay? This comes out of a real agreement, but that's probably one of the extreme sides, and you really don't want to handle that. This is not super fair. If a contract's designed to avoid disputes, this just creates uncertainty, and that's all that's doing. What's the bottom one? Unless required by applicable law, agreed to, everything's provided as is, no warranties, no conditions of any kind, very common language. So that's kind of the other side. Hey, here you go. If it breaks, sorry. All right, well, that's not necessarily what you paid for either. So you've got to really figure out where the line between this thing is, also how important that software is or isn't to the company and what's going to happen. There was earlier talk today that was talking about, well, here's what ends up happening if there's a breach or not a breach. In the poll that I sent out, the respondents, one of them was, we're concerned about the PR. That's a legitimate concern communication plan. A fair number, about half the people-ish, said, we're worried about the breach, we're worried about losing data, we're worried about this, we're worried about that. Here's my philosophy. I own an automobile. It is going to break down at some point. What is my reaction to that? It's irritating, I can't stand it, but if you really think about it mentally, car problems are irritating because we don't expect them and we don't like them. As long as it's built by a human being, it's going to break at some point. A breach is going to happen at some point. That's just all there is to it. It probably already has for a lot of people. It's just that the harm wasn't there. You got to be able to figure out contractually how you want to handle that. Open source. So open source has got a neat little thing that's out there. There's a lot of open source. There was a survey done, I can't remember when it was, but it was 5-10 years ago. 70% of the CEOs said that their companies were not using open source. 70% of them were wrong. The CEOs don't know what's going on in development. I was a programmer. Good programmers write code. Great programmers use code from other projects. Okay? That is just that's the way the world works. Where that other project came from, we don't know. I like open source. I think it's helpful. I think it solves a lot of problems. It tests the code, but it creates some issues. This is for the Apache license, flat out says you can easily find information of known vulnerabilities for an Apache project. So they're just flat out throwing it out there. Hey, look, there's going to be probably vulnerability problems. Here's where you go look for them. Good luck. So when you've got a vendor who's using open source, in the contract, you'd be able to say, all right, what's the deal here? Exactly what are you using? How are you doing it? I'm starting to see a lot more of that with the open source stuff. If I'm on the software developer side, I represent a lot of software development companies, I say, look, we're using open source. That open source may or may not have vulnerabilities. We're willing to warrant that just as much as the open source license is. If you don't want us to use open source, that's fine too. We have to write everything from scratch. We need to revisit the pricing. That is a legitimate conversation. You know, have that conversation, but you got to know you need to have it to bring it up. I won't get into the GPL, GNU conversation. You guys know about that one. It's an infectious license that I'm not a huge fan of anyway, but I won't get into that. All right, so Agile, Waterfall, and cybersecurity. I'm starting to see a lot of this. This is where I'm starting to see Agile, Waterfall, and cybersecurity. First of all, when we're in front of a court, I've got to spend a lot of time explaining this. The typical court and jury is not going to understand what we're getting ready to talk about. That is a challenge. How am I doing on time? Good? Oh, perfect. So the Waterfall, Agile, and cybersecurity, we're starting to see that. I sent out a poll. The majority of the people said that their vendors are saying that they're using Agile, but they're really using a hybrid. What's a hybrid? Part Agile, part Waterfall, part something else. That was about half. About a third, or less than a third, said the vendors are using Agile, but they're really doing Waterfall. And about 10% of the respondents said, our vendors saying they're using Agile, and they're not. Okay, so that's what we're getting right now. Agile is being tossed around. It's a great idea. If you go look at Agile from a purist standpoint, it was designed at the beginning of a software project. It was never designed to be the complete solution for writing a software. And for those that you don't know, this is what Agile kind of looks like. On Monday, I stand up. Hey, what would you like your project to look like? I'm just going to use a car example because it comes to mind. I want you to build me a car. Fantastic. All right, let's sketch it out. What do you think about this car? Week later. Oh, it looks great, but can you put 4 wheels on it instead of 3? I like the fact that you got a tire in the back, but I need 4. Happy to do that. A week later. Love it. Can I have back seats? Yeah, back seats are great. Can we do that? So this project goes, and it's very agile because you get to constantly change what you're doing. Okay? Now, here's the problem. How many people in here would be, no, you don't have to answer. Most people here, if I came up to you and I said, I'm going to build you some software, how much is it going to cost? Can't tell you. How long is it going to take? Can't tell you that either. Well, what's the process going to be? When are we going to know we're done? Well, we're going to be done when you say we're done. Okay? Does that sound like a lawsuit, by the way? Okay? So when the agile process is just that. The problem is that this is not happening in the real world. You've got contracts that are using agile, or at least components of agile, with a deadline, milestones, and a price. The agile process itself is designed to not have a lot of structure to it. So when a software developer says, I use agile, and then actually implements even part of an agile process, it's very easy for them to blow through their deadlines and their costing, and then now we're in a lawsuit. I can use that against you, and I can use that for you. If you tell me as a software vendor you are using an agile process, and we put that, even if it's not even in the agreement, if it's somewhere else. If I say you're using agile process, and then the customer starts complaining because it's taking too long and costs too much, if they agreed to the agile process up front, it's not costing too much or taking too long. We're not finished yet. You agreed to agile. I can go the other side of that. Hey, software developer, you said you were using agile, but you gave him deadlines, and then you gave him a hard dollar amount. So you're not really using agile, are you? You're using a hybrid. So you misled them early on, didn't you? Now you're starting to see what I mean by the way the contracts are reading. Okay, that's not fair. I'm seeing a handful of people recognize the issue with agile, waterfall, and hybrids and handling it contractually. The vast majority I am not seeing at all. A good attorney can take advantage of it on both sides, and they really can. What is that? Here's the problem right now. People are saying, do you use agile or not? It's this very binary situation. Yes, we use agile. It's very unlikely someone's using pure agile because it just doesn't work. It was designed for the process. We understand that poor perfection times cost resources are going to be limited. Documentation will be limited. Okay? I will confess, as a computer programmer, I perhaps was not the best at documenting my code. Okay? I knew what it meant. When we get into litigation, everybody expects code to be documented. The agile process was designed to remove some of that stuff. Where's your documentation? How's the client supposed to know what's going on? So the contract for agile needs to be different. It even needs to be, say, we're using an agile process, and the documentation is going to be limited. If you would like us to fully document our code of this project, this is what the cost is going to be. That's a legitimate conversation as well. The concept of project completion, very fuzzy. Because if you really think about pure agile, you're finished when the customer says you're finished. All right? Difficult thing to do in a contractual basis. KPIs are, in my opinion, almost impossible because what you end up having to do is, how are we doing on track? Well, in theory, if you know what a sprint is or the Scrum method or all that kind of stuff, the project calendar is changing constantly, so it's very difficult to say, are we on track or not? Most you can probably say is, yes, this sprint's on track. No, we're late on that sprint. I mean, that's probably the most you're going to get out of that. So anyways, this is the agile process. Everything's gears are taking. They're taking traditional software development agreements, and the legal profession is trying to make agile fit into a software development agreement. And I'll be honest with you, it is simply not working that well. Okay, so try to really, really understand what your client's doing, and the companies understand what your vendor's doing, and then the next thing you know is put those contracts together. Now, I really actually don't have any more for you, but I'm happy to take questions. However, I will tell you this because of the time we're doing, and Callie says we've got a little extra time. If there are any questions, Susie and Kim will be happy to answer them for you. Okay. Thank you very much.